My name is Morgan Brien, and I'm joined today by my colleague James McHugh.
Hello.
We are both members of the housing group in Trinity Chambers and have some experience of injunctions in an anti-social context. The purpose of this hopefully short webinar is to provide an update as to the current position with regards to injunctions, advice about what you can do and what you need to do to secure one. Before we get into the nuts and bolts, James is going to provide a very short summary as to what is happening with possession claims generally.
Yeah, thanks. The purpose of maybe going through this was obviously in response to the new practice direction 51Z, which has effectively put a pause on possession proceedings until the end of July. That's left landlords wondering a little bit, what do they do with problem tenants? The good news is there's a couple of updates in relation to the possession position. Firstly, there's been a recent update to Practice Direction 51Z that confirms that it doesn't apply to trespassers. So you can still bring possession claims against trespassers. The second sort of bit of news is that on the 30th of April, the Court of Appeal is due to hear the appeal in Arkin and Marshall, which is concerned with whether or not, in fact, the stay on possession claims is lawful at all. That won't affect this talk too much as we're talking about injunctions, but that's kind of an updated position on where we are with possession claims.
Thank you, James. The position with injunction cases is, like possession cases, they can, of course, be issued. The distinction between the two, save for where trespass is a feature of a possession case, is that injunction cases can and will still be heard as they have been given a priority listing, as will committal hearings. There is therefore no reason at present why you cannot apply, obtain, and if necessary, deal with the breach of an injunction. A recent example of this was in the widely reported case of the University College London Hospitals NHS Foundation Trust and MB. Unusually that involved a licensee in a hospital. The hospital trust applied for an injunction to exclude her from the hospital bed, and the judge agreed with that procedure. That is likely to have been changed somewhat as that decision was decided before the update to the practice direction came out, but it does serve as a useful example of how parties can obtain an injunction in the present climate. James, one question that many people have is, what can a landlord, a local authority, or a social housing provider do in the case of a tenant committing antisocial behaviour?
Yeah, it's a good question. And the sort of headline point is that the position in relation to the law is exactly the same as it was pre-COVID-19. You still look at part 1 of the Antisocial Behaviour, Crime and Policing Act, and that effectively leaves you as a landlord with 2 options. You can either apply for a prohibitive injunction like an ASBE, targeted at stopping specific behaviours, or perhaps in more serious or repeated cases, you can apply for an exclusion order prohibiting access to the property. But as I say, that despite COVID-19, the main point to take from it is that the law remains exactly the same, and your options in relation to applying for injunctions as a landlord aren't affected.
Yes, James, I think that's probably one of the most important pieces to take away from this webinar, is that the fundamentals of the law have not changed in terms of what a party needs to establish and what needs to be proved. Assuming you have got that evidence and can make that out, one question is, how do you actually demonstrate it? Many people will be aware that the rules in relation to witness statements have changed as of the 6th of April. There's 3 important points that we wish to set out if you're not already aware. Firstly, a witness statement must now set out the process in which it has been obtained. There is nothing wrong with taking a witness statement over the telephone, and in fact that is likely to be the case now for the foreseeable future. However, if it is taken over the phone, it must include this in the witness statement. Secondly, the statement of truth has been amended as is set out in the new practice direction. That includes a reference to the author of the statement, confirming that they are aware and understand proceedings for contempt of court may be taken. We would advise you to look up the precise words and to get that right. And thirdly, in relation to a signature, there is as yet no guidance that precludes the use of an electronic signature. The advice would be, if one can obtain a proper written signature, we would advise that to be done. If, however, there's issues with that, an electronic signature should suffice, particularly if the witness is providing evidence over video link or in person. Having got the evidence, James, what does a party need to do to issue the claim in the current climate?
So the important thing to bear in mind is that, again, the rules in relating to issue haven't changed. This still falls under county court work. That's not been affected by COVID-19. The rules relating to issue haven't been affected by COVID-19 in this area. You don't have to issue in a more specialist jurisdiction. Certain local court centres might have adopted their own practices for the issue of proceedings, and certain local court centres might be accepting electronic filing, but that is very much on a centre by centre basis. And the safest assumption, I think, in the circumstances is to assume that you're going to have to issue as you normally would, unless you've been specifically told otherwise by your local court and hearing centre. Moving on from that, Morgan, are you aware of any issues in relation to the service of either claim forms or statements and applications in these proceedings? This is often a jurisdiction that requires personal service to be effected.
Well, firstly, we are not aware as yet that the rules have changed, and clearly there are serious issues over affecting personal service. And it depends largely on the nature of the application. If there are grounds for making it without notice, service or the points in relation to service can be addressed at the hearing. If, however, it's an application that needs to be made on notice and personal service is a requirement, the advice would simply be make every effort to effect personal service, save for breaching the social distancing rules. And that will require a little bit of thought from the parties, as well as the process server. Could include the use of video, audio recording to show that the party's notice has been drawn to the document. Could also include the use of a phone call, email to inform them about it. But the important point is the rules as yet haven't changed, and it is going to require some thought to ensure that the rules have been complied with.
Yeah, and just to build on that, I think you're right, because the tenor of the case law pre-COVID-19, which I don't think will have changed now in relation to service, seems to be that the courts are much more forgiving if you've made an effort to serve than if you haven't. So I suspect that the court will take into account the fact that there are strict rules in relation to social distancing and are possibly going to be more amenable to applications to amend methods of service in times like this.
Yes, I think do something rather than nothing is always good advice. I think on that point, we can probably leave the webinar. Summary of the position as of today's date is that parties can and still will get their injunction applications heard. The fundamental law has not changed. The evidence required remains the same. The rules of service, as we understand, remain the same, but they are going to require a little bit more thought. And hopefully this provides a useful summary to all in terms of injunctions and how one can go about applying for them. If there are any queries on any of the above topics, please do not hesitate to get in touch with us. Equally, if you would like us to discuss anything else in future webinars, please let us know.